Hello, my name is Ryan Meyer, and this is my presentation for week 4 of EDU 503 Sports Law. The case I chose for this week comes from Chapter 9, and it is the Dallas Cowboy Cheerleaders Incorporated versus the Pussycat Cinema Limited Company. And this court case took place in 1979. I actually chose this case because I'd actually come across this in my media law course that I had in undergrad. So this case features the plaintiff, which is the Dallas Cowboy Cheerleaders, and Pussycat Cinema. And in this case, the plaintiff filed an injunction against the Pussycat Cinema company from distributing the film Debbie Does Dallas. The reason they filed this injunction is because the plaintiff felt that the film Debbie Does Dallas had committed trademark infringement. Dallas Cowboy Cheerleaders is a wholly owned subsidiary owned by the Dallas Cowboys Football Club, which have been famously shown on television shows and commercial appearances, so they pretty much have their own brand. The Dallas Cowboy Cheerleaders have gained national attention and have had tremendous success in selling merchandise such as posters, calendars, t-shirts, and their specific uniform that consists of white vinyl boots, white shorts, a white blouse, a white vest decorated with 3 blue stars on each side of the front, and a white fringe bottom. So a pretty specific uniform. Well, Pussycat Cinema, which is a theater in New York, showed a movie called Debbie Does Dallas, and the film plot is about a cheerleader at a fictional high school who has been selected to become a Texas cowgirl. In order for Debbie and her cheer squad to get to Dallas, the cheerleaders perform sexual favors for a fee. And in the final scene of the movie, Debbie, the main character, performs about 12 minutes of sexual acts while wearing a uniform that's very similar to the uniform of the Dallas Cowboys cheerleaders. So there's a few issues on hand here. The plaintiff filed an alleged trademark infringement, unfair competition, as well as dilution of trademark in violation of the New York business law. And the excuse me, the preliminary issue that was raised by the defendant was if the plaintiff had a valid trademark on his cheerleader uniform. The court ruled, in quotes, disagreeing with the defendant's assertion that the uniform is purely functional. The court stated that it was well established that if the design of an item is non-functional and has acquired secondary meaning, the design may become a trademark even if the item itself is functional. So essentially, even though the Dallas Cowboy Cheerleaders did not have a trademark on the uniform, since it had grown such popularity, and they were essentially making money off of the merchandise that they were selling, since it's not a non-functional design, therefore it's automatically a trademark, essentially. And then the court also ruled that the uniform that was depicted in the film, Debbie Does Dallas, unquestionably resembles the Dallas Cowboy Cheerleaders uniform. So, while reflecting on the case, I wondered if the Dallas Cowboys Cheerleaders Incorporated would have filed a suit if the movie was not of a sexual nature, if there was a more positive light on the film. I wonder if they would have been fine with the uniform being used, maybe for advertising purposes. But since it was a sexual and kind of a negative movie, I wonder if that played a role in the reason that they were, or that they did end up filing an injunction against them. And relating this back to, becoming an athletic administrator or an athletic director, I think it's very important that when designing things for your athletic program, to always be original, so don't just copy someone's design, especially notable ones, and then also run any sort of logo or uniform idea that you think might have issues clearing a trademark or a copyright or anything of that sort by the school district attorney, just to make sure that you're not using anyone else's trademarked ideas or anything that could potentially get you in legal trouble. In terms of athletic department, it's always good to run anything that you're going to use and or purchase by your legal team before you spend money on purchasing items that you might not be able to use, because you might just be wasting money and time.